If you want to take care of minor children after you're gone, do not name your guardians that you've chosen as the beneficiaries of your accounts. If you've chosen guardians for your children and you've discussed with them ahead of time that if something happens to you, you want them to be the caretakers of your children, it'd be very tempting to name them as the beneficiaries on the accounts that you intend for to be spent on your child. The money does get to those guardians. However, here's the drawback. You've legally made the money belong to the guardians without any legal strings attached to it. And so what that means is that belongs to the guardian. If the guardian themselves is incapacitated, if they're on Medicaid, if they're going through a divorce, if they're going through bankruptcy, if they have creditor issues at the time that they receive the property, they have legally become unable to use the money as you intended it for the minor child. It's their money. The laws say that it belongs solely to those guardians because you arranged it that the money is transferred to them. What you're trying to do is to have the guardian hold the money for the benefit of the child. And what that is a trust. You need to put your trusts in writing to make them legally enforceable against third-party creditors. So it's an important step to ensure that if you want the guardian to use your child's inheritance until that child reaches a responsible enough age, that those terms are put in writing. If they're not in writing, no creditor or divorcing spouse is going to know or care that you intended that money to be spent for your child rather than the guardian's creditors. So if you have minor children, it's vital to be setting up a will or trust that designates how the property that you're leaving behind will be used until the child is old enough to receive the property and that they can receive their inheritance outright. Good estate planning documents that take care of minor children have sections set up that says that if any beneficiary is under a designated age, say 25, 30, you get to pick the age. You could say that if you're worried that your children won't be responsible enough until they're 65, you can put that down. It is important that if you are caring for minor children, to arrange for that their inheritance is going to be looked after by responsible parties like a guardian, is to establish a will or trust that says so. I traditionally refer to them as contingent trusts for minors. But in either document, a will or trust can say these things. There's a section that says if there is a beneficiary who is under a designated age, rather than that beneficiary receiving the money outright, we will hold it for their benefit, and you designate who is in charge of that money for the benefit of the child. One great advantage of this is that you can designate the caretaker of the money, which they're called a trustee. You're entrusting them with this money for the care of the child, and that money isn't locked in place. The money is still available and fluid. It's just this trustee has the checkbook, and you can leave directions to the trustee on how to spend the money on behalf of your minor child. You can say that the money can be available for the child's upkeep, for their educational expenses, for their health care. If you so want to, you can also keep it restricted. If you want the money more to be available once the child becomes an adult, you can specify exactly how the money is to be used for the child until they reached a designated age. However, if you give it directly to the child or to a guardian, that plan falls apart. If you name the child as the beneficiary, in Kansas, they'll require you to go get a court-approved conservatorship. If anytime someone under the age of 18 receives an inheritance, the court steps in and requires a conservatorship to be set up. It's a court-supervised process that requires conservator of the money, whoever's in charge of the money, to account to the court on an annual basis and to jump through the hoops that are required with conservatorships. Generally, those conservatorships automatically terminate once the child reaches 18. And it's the judge who will be picking ultimately who the conservator and caretaker is for the money once it's in that conservatorship. By setting up a well-drafted will or trust, you can designate ahead of time who the trustee is, who will be in charge of the money, how long the trust will be in existence, and the terms of its payouts during the time of the trusteeship. If you don't have this in writing, there's nothing that's going to enforce it legally. That's why it is very important, if you have minor children, as soon as you have your first child, you need to be putting your wishes in writing to care for those minor children. If you're trying to arrange for the inheritance of your minor children, do not write your guardians as the direct beneficiaries on your accounts, and do not write your minor children as the direct beneficiaries on your accounts. It is important to be meeting with an attorney to put in writing so that it is legally enforceable to the whole world what you intend for your money to be spent on for that minor child, who is in charge of the money, and when the child is old enough to receive the money without a trusteeship.